Now, estate taxes aren't a big deal anymore because, well, that's unless you have $13.62 million per person or more. And if you do, we can be friends. I can help. Um, but most of us don't. So now what we're worried about are some other things like, the next big predator on a family's finances after the taxes are not a concern is long-term care costs. And so started getting into that. And yeah, I found out actually during practice that the financial savings of estate planning, in my opinion, aren't as important as the emotional cost savings in
Hmm.
estate planning. Um, but that's my own personal opinion. Not every client feels that way, but that's how I feel about what I do. Uh, is that it's important because it helps people. So let's talk about three phases of life. Okay, so we've got while you're alive and well. We've got while you're alive, but you may not be well anymore.
Uh-huh.
And I'm talking about not physical health. I'm talking about um, you are no longer competent to manage your finances. And then we've got when you're dead. Okay.
Okay.
So let's take a look at the the alive and well piece here. You didn't get to see the trick because it went off camera,
Oh.
but I just unlinked the linked ropes. Okay, so you have three options to take care of stuff in estate planning generally, and those are we have three plans: the do nothing plan, in which case the legislature in your state has a plan for you. Now, Stephanie, I assume that's you on the left of my screen and that you have your husband with you.
Uh, this is Chris, boyfriend. But yeah,
Boyfriend, Chris. Okay. Stephanie and Chris, are you in Kansas?
yes.
Okay. So I won't have to talk about multi-state things. We're just going to go straight Kansas. Okay. So the people in Topeka, they have a plan for you. And that plan says, it really, it's called probate, right? We have family courts, we have criminal courts, we have probate courts. Probate courts take care of adoptions, they take care of guardianships and conservatorships. They take care of what do we do with your stuff when you're dead. And that probate, the best definition I've ever heard came from another attorney named Peter Parenti. He said, probate is a lawsuit that you file against yourself with your own money in favor of your disgruntled heirs and creditors. It's not set up for you, it's set up for everybody else because we just have to be fair, is the idea. Anyway, probate costs money, causes delays. And so most people hear that they want to avoid probate, they may not know why. Um, but we want to try. The do nothing plan doesn't avoid probate. So the next plan is a will based plan. And I've talked to a lot of people that think that they have a will and they're done. And because we watch movies, right? And we know that the people sit down in the attorney's office and the attorney tells them what they get. That's not the way it works at all. Not even close. The will is a set of instructions to the probate court that tells them what you would like to happen. And providing everything goes smoothly, it will probably happen, but there's those times where it doesn't. For instance, the attorney down the hall from me just closed up a probate case that's been going on 6 years. He closed it up about 2 months ago, uh, just because stuff came up that was unanticipated, like some girl in Southwest Kansas that said, "Oh, by the way, that man had an affair with my mom. He's my father. I want a third of his assets. And that, that wasn't even the thing that's taken the most time. That was one of the wrinkles in the case. Anyway, so
Not fun.
those are two options. And then a third option would be private contract, where we wrap everything we have up inside of a contract that that stays outside of the probate courts, and we deal with it privately. Guesses on what the private contract is called?
Okay.
A trust, of course.
Trust.
Yes.
Yeah.
Yeah. Okay, so there's lots and lots and lots of different types of trusts. Okay, so now we've gotten through that options piece. Let's talk about, again, the piece of your life that's while you're alive and well. Okay, so does a will do anything for you while you're alive and well? No.
Supposed to give you peace of mind.
Oh, there you go. Okay, a will isn't even considered a valid document until a probate court has accepted it and says that it is. So you're dead. Okay, doesn't provide any legal assistance while you're alive and well. The do nothing plan also provides no legal assistance while you're alive and well. To be able to do stuff, you have to have legal authority. Now, Stephanie and Chris, while you're alive and well, you can manage your own stuff, but also while you're alive and well is the only time when you can plan for when you can't manage your own stuff. Mm-hmm. So you're walking along and you're carrying all your stuff. I've got stuff I can carry here, different things. And I'm walking along and I'm carrying these, and people know that they're mine because I'm carrying them. Now I fall down. Maybe I'm in a coma. Something happens. I can't carry these anymore. Who gets to pick them up? So if we've done the do nothing plan, who can pick up my stuff, has legal authority to pay my bills, to deal with things? Absolutely. Well, mostly nobody. Sometimes a spouse, to some degree, but often nobody. And so what we need to do is we need to go to the probate court and we need to get a guardianship over me or conservatorship over me and my assets. So it's going to take a while and it's going to have some more expense.
And can I say something, Mark?
Determination. Yeah, go ahead.
I know, like in the real estate world, we deal with some of those documents, and there's a huge difference. People think just because they have power of attorney, that means for real estate also, and it does not, of course. So you might just go touch that a little bit.
Okay, well, it can, but it doesn't always, right?
Right.
It depends on how thorough the power of attorney is. So lots of times when people get a power of attorney, it's a form that's based on what's in the statute books. And so you say, hey, somebody comes in my office and they say, hey, my husband is sick and I want to do planning for him and myself. And I say, great, let me see your power of attorney. And what kind do you have? I don't know, the regular one. So I look at the power of attorney and it's missing the authority necessary to do the planning that they want to do. It would also probably be missing the authority to sell the homestead, if that's what you're talking about.
Right, because I had two different ones for my parents. One was making decisions. The other was the ability to buy or sell any of their real estate.
Okay, yes. So we typically have two types of power of attorney. The state forces us to separate them. We have one for healthcare decisions, and we have one for everything else. And in the everything else one, there are some stipulations. I mean, we used to just say, hey, you could do whatever I could have done if I was able to do it. But that doesn't fly anymore. So we have to list specifically a lot of things. And several of those things are not in the statutory form. For instance, if you want to sell your home that you had together, then you have to actually like list the address of the home, and and have spousal consent, and so that's not in the form. Okay, so just doing the cheap version, of the do nothing, or just trying to do a will, even if you've gotten a power of attorney online, it may not hit everything you want it to hit. So what do? You give more powers. Well, then the person has. I mean, if I give you a blank check, what can you take from me?
Everything.
No, you can only take my bank account. But if I give you a power of attorney, what can you take from me? Right? You can take. That's when you can take everything. So you have to have. You want to have instructions and limitations built into the power of attorney that limit what the person can limit how the person can use those powers. Give them all the powers that they need, but limit the use of those powers to be in compliance with your estate planning and for your benefit in a fiduciary manner. Anyway, so that's while you're alive and well with when you become disabled, actually. So we should be looking at, okay, now I'll show you they're together.
You want to see this?
And they're apart. Okay.
Okay.
So, yay. So we have the piece when you become disabled. Okay, that's really what we're talking about. The best thing you can do with that is, in my opinion, if you have the private contract and you have your assets already taken care of inside that contract, is the contract says, if I become disabled, this is who steps up, this is what they can do, and how they should take care of me, and how they should take care of my stuff. And the handover is smooth, and we even write in there how we determine if I'm disabled. So we don't have to take me to court to get that type of determination. Where was I going?
That's interesting.
So that's it. It's really, really helpful during life, as well as taking care of stuff after death. A trust plan covers while you're alive as well. And sometimes it's not that you're incapacitated. Sometimes it's just, look, I'm on a business trip, or I'm on, I went down to do Greenpeace stuff someplace, whatever. I'm not there. I want somebody to be able to help out. And so I could I could appoint a trustee to move in and maintain my house while I'm gone and pay my bills and whatever.
Mm-hmm.
So it's something that can be used while you're alive, and covers a lot of what attorneys plan for is all those worst case scenarios that could come up. And we're going to talk about some of those. That's the fun part for me. But we'll do this. Okay, so there's kind of a cheap alternative, kind of middle between the will and the trust. And this is what I hear a lot of people talk about using. And they say, well, okay, I have a will, but I'm still going to avoid probate because my attorney or my financial advisor told me to go put beneficiary designations on everything that I have. And that, if it works, it could avoid probate, and it'll be really cheap, except for your legwork doing it. So what we're talking about is, okay, so now I'm going to bring out the magic trick. Okay, so we have these ropes represent different assets. Let's say this is a bank account, okay, the yellow rope. And the green rope maybe is an IRA. And the white rope here is our house. And then I've got a brokerage account, that's Blue Rope. And then this red one is a car. Okay. And I've got 3 kids. So what do I do with the bank account? Well, I put all 3 of my kids as beneficiaries on it. Okay. Now, the magic is this. Most of these are going to work. One is not. Stephanie, you get to decide which one's not going to work. And I know which one it's going to be. So tell me which of these is not going to work.
Let's say the car.
Okay, the car. So that's the red one on the end here. Now, so you didn't know that the car is a Bugatti, so it's got a lot of value to it. They could sell it and, divide that.
Okay.
But we said the red one. So now let's pull out one of the other ones. Tell me a color to pull out.
White.
The white. Okay, so the house, that went smoothly. We got the house out of this, it went straight to the kids. They all agreed because they never fight. Kids never fight. We didn't know that, but they don't. And they sell the house and they split the stuff up equally. Okay, now pick one of the other ones to pull out.
Blue.
The blue one. What was the blue one? I think that was a brokerage account. That was easy to split up between them. In fact, we just, kept it with the same broker and just divided it up. And now we have 3 accounts. They have the kids' names on them. Except that there's that one kid who's getting sued. So his is going to go away. But, but we got it out. We didn't have to go through probate for that. So that's good anyway. Okay, so now, also, you can change your mind, too, if you want.
Is there one who's going to pay for your funeral? Because none of them are going to want to do that.
Yeah. But we're leaving the Bugatti for them. That's going to be enough they should pony up to pay for the funeral.
Everything's in the details. It's got to be in writing.
Okay, so Stephanie, are we sticking with the Bugatti is the one that's going to get messed up, or are we going to change our minds?
Oh gosh, we'll just stick with it.
Okay, so which one are we pulling out now?
Is it possible to have? I don't think bank accounts can have beneficiaries, can they?
Yes, they can.
Yeah.
You can do transfer on death, pay on death to bank accounts.
Okay.
So that, and that's the easiest. They just pay that right out. And that one comes out, and it's just fine. Okay, so now all we have left is the IRA. Now, there's lots of things we can do with IRAs. We're gonna do beneficiary designations on that. I wouldn't put the IRA in a trust anyway, because then we lose the tax deferred growth or tax advantaged growth if it's a Roth. But my beneficiary would be the trust. But we're not doing that. We're just going to the kids. Let's do this. Well, okay, I'm going to pull out the Bugatti. It didn't get messed up. So I told you that you would pick the one that's messed up, right? Okay. It doesn't come out, and you want to know why? Let's see if you can pick this up. I'm going to lift this straight up out of here. It is
wrapped around.
Tied on.
Tied.
Okay.
Until you're 72.
Okay. Now, how did I know that? It doesn't matter. But what happened was, okay, we had 3 kids. One of them died. Now the Bugatti went to 2 kids, and we have to have the other portion. It can't go to the kids. So does it go to the kids' estate, or does it go into probate from our estate? It goes into probate from our estate, most likely. And so we didn't avoid probate on that one. Okay, well, what if we left stuff to the kid, but that kid was in the car with us when we got into a car accident, and now we're dead, but that kid is disabled, and all the stuff we left to them, the IRA, the house, whatever, in their names, makes it where they can't qualify for the government benefits they need because they're going to need to be in a facility for the rest of their lives. And until they spend all the stuff we left for them, they can't qualify. Is that what we intended for that stuff? No, that's not what we intended. Now, if everything goes smoothly and nobody has messy lives, because nobody has messy lives.
Such a rarity.
Yeah, then it might work just fine. But if there are issues, then we could have problems using that to get out of probate. So let's talk about what some of those issues are. Let's see. So okay. I have one of your children here. Okay. We're going to put the child in this little case and close it and lock it up. Let's see. Okay. So now he's not going to get out. So we have a little sword. Okay. And this is, I don't know. We have a blended family. So when one of the spouses dies, the other spouse who's left is going to try to get rid of the kid that was from the deceased spouse. Or maybe we didn't have a blended family originally, but then after dad died, mom got a new friend. And so now we have a remarriage problem, and dad is spending all the money on that new friend, and nothing's going to be left for the kids. That's another thing that could happen. How about what happens with the kids? Okay, so this kid is I'm his parents that made this stuff. They're 80. This kid's 50. He has 3 kids in college and grad school. They're applying for financial aid. Grandma dies and leaves a bunch of money to dad, and now I no longer qualify for financial aid. So you've just kicked all the grandchildren off of financial aid. What if one of the kids has an addiction? Okay, so you really want to kill somebody who has an addiction, give them a lot of money. So we're going to kill, They had a surgery. They got addicted to pain meds.
Mm-hmm.
We all have seen newscasts where it's happened. Happened to my wife. Took a long time to get off of it. But if you have, life keeps you in check. But if you just leave a bunch of money to somebody, then they can get whatever. If they can't get the prescription drugs, they can get something else, and
Right.
they'll end up killing themselves. Okay, let's see what else. What if we have a kid who's a spendthrift? Meaning, you give them $1, they spend 2.
Mm-hmm.
So the money's going to go away really fast. I had one client. She called me. I respected her. I respected this daughter who she was talking about, that this daughter had a shopping addiction where she ended up getting a $30,000 credit card in her mom's name and maxing it out over a very, very short period of time. So that kid, you don't want to be in charge of their own money. What else? Oh, so I have a kid and they get married to their dreamboat, who I hate. And, then I die and leave a whole bunch of stuff. And all of a sudden, Dreamboat says, you know what? I've met a new friend and I'm giving you my divorce papers and I want half. So I didn't really want to pay for my ex-in-law's house, but if I just give it to him outright, that's what I've done. Okay, so we got lots and lots of things. Okay, who has disabled beneficiaries? Anyone know? Any of you have disabled beneficiaries? It's a trick question. You don't know. Okay, here, do this with me.
We could, but we don't know it yet.
Right, that's it. If you can do this and you feel this little bumping sensation, you're alive, right? Okay. You don't have beneficiaries, not yet.
Right.
And you don't, if they're in the same car with you when you get in a car wreck or whatever, we don't know what will happen between now and when we have beneficiaries. Some of them could end up being disabled, or we could end up with underage beneficiaries. I meant to leave it to my kid, but they were on a family vacation, and the only thing that's left is a grandchild who's 5. They can't manage their own stuff. And who do I want to manage it for them? Well, if I just left it to them, I don't have any of that stuff. But if I write it up in a private contract, I do have that stuff. So, we don't want we don't want to just stop with this guy, right? So if we have taken good care to make sure that all of these things are dealt with,
He gets to come out of his
then,
cell.
and he's still fine.
Aha, no holes.
Okay. No holes. That's right. I went through a lot of stuff really, really fast, and I skipped a whole bunch. I'm trying to figure out. First of all,
So living will, is that what most people have? And we see a lot on real estate, 50%. So
let's talk about so lots of times we have deeds done wrong too, because people are going to say, hey, I just want it to go to my wife, and then she'll do a new deed to give it to our kids, or in her will it'll go to our kids, whatever. I die and my wife thinks she has the house. Well, that depends on what the deed said. Did it say joint tenancy with right of survivorship? Because Kansas, if it doesn't say, Kansas doesn't favor that. They'll say it's tenancy in common, which means I owned 50%, she owned 50%. Now I die, and my kids are trying to get the house, and they find out they can't get the house because I can only give them half of it, because half of it still belongs to my deceased spouse's estate, which was never opened because we thought everything just went to me. Stuff happens unless you have somebody who knows what they're doing, trying to take care of things. Okay, so there's this thing out there called a small estate affidavit. If your estate is $75,000 or under, that was just bumped up from 40,000 a couple years ago. Then you don't have to go to probate. You can use a small estate affidavit to be able to transfer stuff to the heirs. The problem is everyone you talk to out there wants to see your court-ordered letters testamentary to be able before they'll move anything for you, and they don't. Some of them do. Some of them know what a small estate affidavit is. Some of them don't. I had a client came in. She'd been struggling for 3 years to get this payout for she and her siblings, and the company didn't help them at all, and she didn't know what to do. Now, for me, it was an easy thing, but that doesn't mean that if you try to do it on your own, you won't struggle. And anyway, so lots of people try to find little workarounds, and sometimes they work, and that sometimes they're like the Bugatti, and something bad happens. My job, I feel, as an attorney, is to teach people what the possible problems are, teach people what the possible solutions are, and then let them weigh the risks and make the appropriate decisions on their own. And with the private contracts, there's so many cool things we can do. Okay. So let me tell you a couple stories. Okay. So dad dies. Mom's living, and when Dad died, they had the trust set up so that upon the first death, the trust split in two, and Mom had her half and Dad's half was supposed to be used just for extras and eventually go to the kids. And Mom was supposed to live off of her half. All right, so now Mom needs two kids. Let's call them Mark and Mary. So, sorry. Oh my goodness. I've gone way over time already, and we're not even. Anyway, I'll go through the two stories real quick. Okay, so we have Mark and Mary, and so Mom says to Mark, he's her co-trustee. She says, Mark, I want to get access to the money Dad left because I need a new car. And Mark says, Mom, you don't need a new car. The 73 Dart is great. You know, the holes where the rust is, let more air flow through. Don't even need air conditioning. It's fine. You don't need that. And she gets really upset and she says, you're fired. And the trust allows her to do that. And then she calls Mary. She says, Mary, I don't know what to do. I'm so upset. Mark wouldn't release funds for me to be able to get a new car. You know how old the car is I'm driving. And Mary says, well, Mom, I think you should be able to drive a Cadillac or whatever you want. And Mom says, well, how would you like to be my new co-trustee? So Mary becomes the new co-trustee. Now, is that the way every trust works? No. It's a private contract. You can do whatever you want with it as long as it doesn't violate the law. It's whatever you dream up that you want to do for your family circumstances. And this is the way theirs is set up. So now Mom gets the car and Mary is her co-trustee. Well, then Mom doesn't want to clean the pool anymore. Dad used to do that. So Mom hires a pool boy, Biff. He cleans the pool in his Speedo. Mom likes that. They become really good friends. And Biff says, hey, let's go to Cabo together. So Mom calls Mary. Mary, I'd like $10,000 more. You were so good about the car. And Mary says, what for? And Mom says, well, Biff and I want to go to Cabo. And she says, well, Mom, that type of stuff's supposed to come out of your half. Okay? Dad didn't want that type of stuff coming out of this half. I won't do it. And she said, do you want me to fire you? And she said, well, you can't. It says in the trust, if you remarry, you can't fire me anymore. And she says, well, I was married for 50 years to your father. I'm not doing that again. And then Mary says, well, Dad defined in the contract what remarriage is, and it's cohabitation for one night. So again, whatever you can dream up in the contract, you can do. Okay, now is that best for everybody's family circumstances? No. But okay, so now Mom dies, and Mary and Mark, they get their stuff, and Mom left it to them in trust. So, and this is the part I was supposed to be talking about. Okay, so you create your trust, and you can give asset protection to your kids that you can't give to yourself, because you're giving them something that's never theirs. So now we left a bunch of money for Mark. We left a bunch of money for Mary. They're each other's co-trustees. Mary retires, moves to Florida, buys a condo, or wants to buy a condo. She calls Mark and she says, hey, I want you to release funds so I can buy a condo. He says, no, Mary, I don't want to release the funds. She says, do you want me to fire you? He says, just listen for a second. Have the trust buy the condo. Like, oh, okay. So the trust buys the condo. The condo is still inside the trust. Then, Mary's husband takes up golf. Mary takes up gardening. Mary's husband comes home one day, says, I want to tell you all about my new best friend I met at the 19th hole. Her name's Bambi. and we're getting matching tattoos and Harleys and going across the country. Here's my divorce papers. Give me half. So in this divorce, does Mary's husband get anything out of the trust? Anything out of the condo? No, because it didn't belong to Mary. It's not part of the divorce. Mom and dad left it for her benefit, but in the trust. Okay. And as long as we provide some specific types of structure within the trust, we'll develop that asset protection for her. And that is I think one of the beautiful things about being able to do trust type planning is what you can do for your kids that you can't do for yourself. If Mary ends up in a car accident and has a head injury, then the trust is going to be managed as a supplemental needs trust. So it can take care of quality of life things while she's on Medicaid, because she can still qualify because that trust is not hers. If Mary dies and this is going to one of her kids and the kid's too young, then the trust is going to say Mark's in charge of the stuff for this kid until the kid gets old enough. And then Mark may still be a co-trustee, however you want to do it. So, so you can create whatever you want that works best for you. I try to point out the different options and possibilities.
You have a question,
Mark,
Linda?
I have one question, Mark.
Sure.
A trust could not be sued. Is that right?
Well,
if you're in a car accident or something like that happens, the trust itself cannot be sued.
That depends. Depends on the kind of trust we're talking about. And the answer is, in most cases, if there's a lawsuit, they can still get at stuff in the trust. In most cases, we're talking about revocable living trusts. But when mom dies, okay, and we have those trusts that go to the children, now the child gets in a car wreck, and that child gets sued. Well, the stuff in the trust doesn't belong to that child. So if I get sued and my mom left something for me in trust, and the court and I my brakes went out, I ran through a whole line of kids waiting to get on the bus. We're way beyond policy limits, okay? And the judge says, you need to pay, and I'll say I don't have enough money to pay, and they say, well, he has this trust. And I'm like, well, Your Honor, it's true that I'm the beneficiary of a trust, but I'm not the trustee, or I have a co-trustee who's not a party to this action, and they won't release the funds, and that money's not mine. Do they get it? No, they don't get it. But they can sue me. Now, there are sometimes if we have something called a hot asset, like a car, that is inside of one of those irrevocable trusts, and that thing causes the damage, it's possible that they could try to sue the trust. But those are very, very limited circumstances. Typically, the trust provides really good asset protection.
Should you put LLCs in a trust?
You can. Yeah, I have done it often. So yeah, you can stick the membership interests in the trust, or you can use within your operating agreement. You can allow beneficiary designation, and you can have the trust be the beneficiary of an LLC interest, whichever. Oh, one thing we haven't talked about, I know we're kind of over, but we haven't talked about long-term care costs and asset protection planning for Medicaid. So there is another type of trust that is often used under all kinds of different names, but the name's not important. We could call it the I Love Puppies Trust. As long as it has the right provisions, that's what counts. And so I can stick my house inside of one of these trusts, and it's not mine anymore, and it can't come back to me, but the trustee of the trust, which is also me, can let me live in it. So I get to live in my house, but it's not mine. Well, it's not mine for property purposes. It is mine for tax purposes. And I won't take the time to try to explain the step up in basis for everybody there. But now, then I go into a long-term care facility. If my house has been in this trust long enough, as soon as I put it in there, they can't get at it. But if it's been in there long enough, they can't even look at the fact that I transferred it. And now that's protected, and it goes on to create a pool of assets that my family can use to help take care of me. And, because if you're on Medicaid, they don't allow you to have enough money to cover anything but a haircut, maybe a Snickers. It's $62 a month. So this could be a pool of assets out here that I've created that they can use for, if they want to take me out to eat or want me to come see them on a holiday or pay for a therapist that Medicaid won't pay for or whatever. And then whatever's left over can go to the kids. So that's been preserved. And I can still qualify for Medicaid.
What's the term that you were referring to? I mean, you said as soon as it went in the trust, they really can't get at it, but then you indicated
it's the 5 years. So Medicaid will look, when you apply for Medicaid, they'll say, okay, I want you to tell me everything that you've given away in the last 60 months. And you put they asked for that in the application. And so if I've made any big transfers in the last 60 months, I have to list those. And then they'll say, you gave away this $300,000 house. We are now going to say you qualify for Medicaid, but you're penalized and don't receive Medicaid for X number of months. I won't do the math right now. So, if I had transferred my house and I'm now at 4 years and 10 months, and I've only got 2 more months to go, I'm just going to wait out that 2 months and then apply for Medicaid, because now they can't look at the transfer anymore. So I've only had 2 months where I had to pay privately instead of whatever that 300,000 divided by 7,425 would have been. It would be a lot. Years. So, and so we find this place in there, a kind of a break-even date where it makes it, if you get past that date, it makes more financial sense to leave that stuff in that trust, because we can undo the trust. It doesn't say that you can undo it, but under Kansas law, and we can undo the trust, or there are other sneaky little ways we have around it. But if we get past this break-even point, I've had some clients in here, for them it was 3.5 years. If they can get past 3.5 years, then they were better off financially than trying to do what I call a crisis plan. And each month they made it past that 3.5 years, they protected more money until at 5 years, everything was protected.
Mm-hmm.
You said there were a lot of different names for that type of trust, and the provisions for what was most important. What are some of the common names for that type of trust?
Okay, so the group that I work with most often, it calls it a Medicaid Asset Protection Trust. I have a buddy in Idaho who works through a different group, and they call it an IPUG, which stands for Irrevocable Pure Grantor Trust. I've heard people just call them 5-year trusts.
Okay.
But I talk about these groups that we're involved with because we have support groups in the estate planning world. You don't come into my office and talk to me, and then I take copious notes, and when you go away, I start typing madly because you would be broke before I got halfway through your stuff. So we have very sophisticated software. There's like 5 different groups out there. The one I use is Wealth Council. the one my buddy uses is Lawyers with Purpose. There's, you know, several others. Trust and Will is another one that's not up to par, I think. Then there's National Network of Estate Planning Attorneys. There's several that just kind of give us the support we need so that we can get base documents then to continue, you know, then that we customize to fit what you are asking for.
Well, and interestingly enough, I was surprised the day that we had lunch and you had said there's no referral system set up between attorneys, whether local in a different division or statewide or international. Yet you do oversee stuff and you know people in other states and areas. So
yeah.
For us as agents, I mean, we have clients that are moving back and forth, and some, I mean, I know of 2 or 3 states that will end up with this video. And I guess I bring that up for the purpose of everything's basically the same, but it's still not going to be the same in every state.
Sure. Yeah. And so if I had somebody come to me and say, hey, you know, my dad lives in Nevada, can you help me, you know, find a referral for my dad in Nevada? I would get on my wealth counsel listserv and say, hey, I'm looking for a Nevada attorney in this area. Mm-hmm. And I would get several responses that day and be able to find somebody that fit them.
And
that's excellent networking.
Yes, because it's so important to us as realtors to be able to refer other agents that we have a relationship with, because it's our reputation being put out there also. And we want to send someone that we know will take care of them. And that's one of the things that I'll say I like about your personality, Mark, is I've always felt like we're all in sync with taking care of our clients. I mean, I've used attorneys before. I go in there, I have a small idea of what I need, and so that's what I ask for. Some attorneys will go, have you considered this option? Or they just go, okay, we can do that. And then down the road, I realize there was a better pathway. And no one, I don't know what questions to ask. And we have to be really careful with that in real estate, because we do it day in and day out. And we have to remember to, you pretend, even if this person we've sold multiple properties for, we still have to remember to not use a bunch of acronyms and go step by step, and explain the possibilities, the pros and cons, because that's what I'm searching for in a professional is, okay, I come to you with some idea and you go, great, but what about this? What about that?
You remind me of something. So, I mean, I do that to some extent with my clients, but honestly, most people who are coming in to do estate planning, not all, but I think most, don't really tell you what their real goals are or try to seek to support their real goals. Because if you dig down deeper, I mean, yeah, okay, so I've got these assets and I just want to split up between these kids equally, you know. Okay, so that's what they tell you. But the real goal is that they want their kids to be happy and taken care of, and they want things to go smoothly for their kids. Now, that one I hear a lot. I want it to be easy for them. But so there are estate plans more expensive than any I have done because they take a lot of work. Where you can structure things with intention to help your children find what they love to do, be the best at it, support them in getting that type of stuff. And you can actually develop a plan that will go on for generations to support the family. I think my favorite estate planning in the story in the world is comes from this school that I had my daughter in. That was a private school. There was this little poor neighborhood next to the school, and there was this one little boy from the poor neighborhood who was in this private school. And this private school is in Topeka, and it's where all the politicians' kids went, the doctors' kids went, and it was, oh my gosh, it was phenomenal. I never knew kids could act so good in a school, but they did. And everybody knew if your kids went to that school that they were set for life. And so this the little kid from the poor neighborhood, his parents sacrificed, his grandparents sacrificed, his aunts and uncles sacrificed. They all pulled together and poured the money into this school to set this kid up for success in life. And I thought that was just beautiful. That is my favorite kind of estate planning, where you're really thinking about what needs to be done for your kids to be able to provide success and happiness.
Yeah, because ultimately that's what we're after.
I really wish they would have planned with, I really would love for people to plan when they're younger. Because we can plan, when you're vertical or when you're horizontal. If you're horizontal, whether it's in a hospital or the ground, it's somebody else doing stuff and trying to pick up the pieces.
Right. Well,
are there limits? Are there limits to the kinds of things that can go in a trust? And does it depend on the type of trust? Like you mentioned a revocable living trust. I assume there's other types of trusts.
The revocable living trust is the most common. That's the kind of foundation for estate planning attorneys who just do estate planning. That's the foundation document. So then we have all kinds of different irrevocable trusts that we use for different purposes. We use them to hold life insurance policies outside of the estate. We use them to be able to transfer assets out of the estate and hold those. In the case of the Medicaid Asset Protection Trust, I mean, I'm setting up for Medicaid, but it's an asset protection trust for anything that happens. It just makes the stuff that I put into it not mine anymore, and also not my kids, because if I would give it to the kids and their lives get messy, then it could come under attack there. So putting it into the trust, that insulates it from me and from them. And whatever the provisions are that I put in there will make the difference on how it operates. But the key thing for the asset protection piece is whatever I give up is what's protected. So I can maintain and I can put in my investment account, and I can keep an income right off of that investment account. So if I get sued, they can get at that income, but they can't get at the corpus, the principal that I placed in the trust.
And I know a lot of people will go, we're going to add our daughter or son or, this person, that person to title to their home. And, what they don't realize is if that child gets into issues, whether it's an addiction or they get mad at mom or dad or whatever, then that comes into play.
Right. And sometimes it's just crazy stuff you could never anticipate. And if you have a kid who's, who gets bipolar or is married to somebody with bipolar or whatever, or I knew an attorney who got in a car wreck and he physically healed perfectly, actually, the motorcycle wreck. But his character was completely changed. And you could just never plan for that stuff. And
Right.
so if you put the kids' names on the title, then that property is now under assault from not only if your life gets messy, but if the kid's life gets messy too. Now it's got double jeopardy to it.
Mm-hmm. And they can prevent you from selling your own
Sure.
home.
Yeah.
Yeah. What else
So
you got?
the Medicaid trust is the one that you're giving up. It's not the living trust, the revocable living trust, where you give up
where you give
title.
Right. So the Medicaid Asset Protection Trust, we're going to put stuff into it that we no longer need to consume. Okay, we can have use of, but not consume. So that trust then can sell my house and buy a new house and let me live in that. If I go into a care facility, it can sell the house and invest the proceeds, but they all have to stay in the trust. I can't take those out and buy myself a cheeseburger. Okay, I can set up the trust so I can give those things to anybody in the world I want to, except for myself, my spouse, our creditors, or our estates. But I can give it to my kids. I can give it to the Queen of England if that's what I decide to put into the trust. And so actually what happens is I set up one of my kids as a trustee, and that kid can give $1,000 to another kid and say, hey, dad needs a new couch. And that kid will buy me a new couch. And I don't have to worry about whether or not those kids are terrible people, because they're the ones who came to my office and said, how do we take care of mom and dad? And if we give the $1,000 to one kid and they don't buy dad a new couch, then that kid's never going to get anything again.
Why do you have
Because
to have it
we
in a
have stuff.
separate trust? Why can't it be in a living will trust?
You mean living trust?
Okay. In a living trust?
Yes.
A revocable living trust? Okay, because if it's in a revocable living trust, it's mine.
Okay.
If I keep it in my revocable living trust, it's mine. Everything I have in a revocable living trust I can access it. If I can access it, my creditors can access it. That's the key.
Okay, I didn't
If I can directly
realize.
access it.
Okay.
Yeah.
So you have your regular trust, and then you have a Medicaid trust.
An asset protection trust that I'm using most of the time to help people qualify for Medicaid quickly and preserve some of the assets.
So isn't
But
it
you
an
have to
asset?
already have that set up.
I'm sorry, I heard two people.
You have to already have that set up. Like I have a regular trust, the revocable trust.
So if you want to be able to protect a greater portion, then yes. Now, if something happens to you, Linda, you get in a car wreck and you're going to need to go into a facility tomorrow, we can still protect some of the assets. If you're married, I can protect the value of all of them, although we're going to have to liquidate some. If you're single, then it really depends on the numbers, on what is your income, what's your cost of care. And so I work out numbers, and we can probably protect maybe 60, 70% of your assets. But if we do pre-planning, like we say, I've got a $500,000 house, and I stick that into a protection trust, and we get out far enough, then 100% of that's protected and isn't considered anymore when I'm applying for Medicaid. The rest of it, we can do the crisis plan with and maybe protect 60%. But whatever I've stuck in that trust, we got 100% of it.
Okay, so I'm a little confused because I thought that anything that was in a trust was protected, but you're saying
No.
if I have access to it, then it's not actually asset protected.
That is correct.
Okay.
Okay, so the revocable living trust is used to manage everything. So if I become disabled, somebody can pick up my stuff and take care of me and take care of my stuff. When I die, there's instructions. Somebody else picks up the reins, pays my final debts, and distributes things the way the instructions say to, and it's smooth and there's no delays. So that we use in place of going through probate. Okay. Now for asset protection, to protect something, I have to give it up. Now I can still control it. Okay. I can create a trust and put the stuff in there. I can be the trustee. That's the manager of the trust. I control it. And I'm the trust maker, the one who made the trust. I just can't be the beneficiary of that trust. But in reality, my family knows that they are going to be distributing those things to each other to take care of me. I mean, that's what they did it for. But not in every circumstance. Sometimes, people just want to preserve it for the next generation. Now, can we? So what you're talking about doing is what's called a self-settled trust. And in some states, we can do that. We can, self-settled trust is one where I put the stuff in and I'm the beneficiary. The revocable living trust is a self-settled trust. Can I get asset protection with those? I can in some states. So I can go to South Dakota. I can go to, well, New Mexico is not very good anymore. I can go to Wyoming. I can go to Nevada is a big one. South Dakota and Nevada are the top, okay, where I can create what's called a domestic asset protection trust. That one, I can put my money in it. And once I get out past 2 years, that money has asset protection. And I can use it for my own stuff, just like a revocable living trust would. But their state laws allow asset protection for those. If I get divorced, my wife can't get it. And for South Dakota and Nevada, there are some states that have domestic asset protection laws that say, except for divorce. So, and then if I want to get really crafty, and because there are a lot of things that people are afraid of with challenges to domestic asset protection trusts, if I want to get really crafty, then I can go offshore. I can. Yeah.
Don't like that, Linda.
But okay, so the difference is if I do a revocable living trust, I'm going to tell you my fees. They're what they are. Okay. If I do a revocable living trust, I have two options. One, if you have nothing and you're just trying to avoid probate, I can do a revocable living trust. I call it a starter trust, and powers of attorney and stuff for $750. Or, you can go to, Staples and get something to do it yourself for $14. Yeah, but that's the quality is, what you pay for. My standard revocable living trust is $3,000 a package. If we're doing the Medicaid asset protection stuff, it's going to be another $3,000 just for that trust, and I'm considering bumping that to $4,000, but I haven't yet. If we're doing a domestic asset protection trust, you're probably looking at 10 or 12. If we're doing an offshore asset protection trust, you're looking anywhere between $25,000 and $50,000. And
yeah, I didn't like that.
I wouldn't. That's right. And I wouldn't be the one doing most of that work because it's not what I do day in and day out. I would be partnering with another attorney and they would get most of the fees. But that attorney, he goes to the Cook Islands once a year and he checks on this stuff, and he goes to Nevis. And so, anyway, so there's options.
Right.
That's really good to know because we have so many younger couples
Mm-hmm.
that have children and such, that a starter trust would be a good place to start with them when they're purchasing their
Yeah,
first home.
yeah, yeah. I mean, you get a trust, you get powers of attorney, you get and the 750, that's for an individual. It wouldn't be that much more for a couple, like,
For a couple.
you know, like another $100.
Uh-huh.
But and we have something called a pour over will. Now, why do I have a will when I have a trust? Well, what happens if you got in a car wreck, you died, and then there's a lawsuit because somebody else was at fault? The money gets paid into your estate. We need some way to get it into your trust. So the pour over will says, hey, if there's anything outside of the trust, it goes in the trust. That's all it's for. They hardly ever get used. The goal is to never have them be used, but you know, we can't control everything.
Right. Well, I thought it was very beneficial. What about you guys?
Very, very good.
Well, I'm
Mhm.
glad.
Yeah, very interesting.
Mm-hmm.
Were there two different trusts at 3,000, or were you just mentioning the 3,000 and then mentioning it again?
So no, it's two different trusts. The
Different
revocable
ones.
living trust package, the estate planning package with the revocable living trust in it is 3,000. The Medicaid Asset Protection Trust by itself is 3,000. I have had a client actually, they wanted asset protection for their house, but they don't have a ton of money. They're still working. She's one of the younger ones, actually. I think she's probably early 50s, late 40s. Um, so she's paying for the asset protection trust, and then she's paying for the starter trust package. So she'll still have pour over will, powers of attorney, etc., and have something that will avoid probate. And so she's having that one. If she dies, the starter trust pours everything it has over into the other trust, then to distribute it with asset protection to her beneficiaries. So she found
Puts it
a
into
way that,
the starter trust puts it into the Medicaid Asset Protection Trust?
yeah, because the Medicaid Asset Protection Trust, when she dies, is just going to split this stuff up and give it to the beneficiaries in
Okay.
their own little trusts. So it just becomes a funnel for, you know, for whatever's put into it.
So their own trusts are going to be their own Medicaid Asset Protection Trust because
Okay,
you don't want
well,
them to not get
it's
financial aid. You don't want them to, whatever the other example
right.
was.
So they're, yeah, their own little trusts. Anytime somebody's dead and they had a trust, that trust, or at least any portion that was just theirs, becomes irrevocable. And so when I leave something for my kids and I'm dead, whatever I've left for them in trust, that trust is irrevocable. They can't change it. So the question is, can their creditors get to it? Okay, so different states have different laws. There's two different ways. Oh, I have a magic trick for this, but I'll not do it because it'll take more time.
Does it matter where it's the state that you're in or the state that they're in?
State that the trust is so my trusts say operated under the laws of the state of Kansas.
Okay.
Okay.
Yeah.
So under Kansas law, I leave my kids stuff. Okay. We have got two options for them to have asset protection. Okay. One, uh, two options that people will like. One option is the kid is not in charge of the stuff I left for them. Nobody likes that. They want their kids to be in charge of the stuff that was left for them. So we have two options for that. One is if that kid gets sued and and they're in charge of their own trust and they can write themselves their own checks, well, then their creditors could stand in their shoes and do the same thing. The court could order them to write a check. Okay. So what we have to do is we have to have a way to remove that child, and that would be something called a trust protector. Now, the starter trust doesn't have a trust protector, but the bigger trusts do. That's something I provide. The trust protector has lots of authority to do all kinds of different things. If there's a change in law, we can amend the trust. If a trustee gets knocked on the head and is dumb now, they can be removed and replaced. If a trustee is the beneficiary and that person gets sued, the trust protector can remove them. Under Kansas law, as long as I have limited the use of the trust assets to something called an ascertainable standard, you don't need to know what that is. I do. Then if they're removed, then they still have asset protection. Okay. The way I like better, because it works in other places besides Kansas and there's no argument about it, is to have co-trustees. So I get sued, and my stories had co-trustees, right? We had Mark and Mary. Mark gets sued, and he says, "Your Honor, I would love to satisfy the judgment out of the trust, but I have a co-trustee, Mary, who's not a party to this action, and she won't release the funds." You have asset protection.
And the court can't make them.
So yeah. There are some situations where the court will, attempting to actually have justice rendered, will do some pretty unique things. Okay, so I know of a case, it wasn't mine. I don't have any clients this wealthy, but I know of a case where this guy had a judgment against him, and he was definitely in the wrong, and there was a lot of money that needed to be paid out. And he had an offshore trust, and he and his attorney were arguing correctly that their trustee wouldn't allow these funds to be used to pay this judgment. That for this judgment to be able to be satisfied, they would have to take the judgment from the U.S. and go over there and get the judgment done in that country. And there's a lot of barriers to them being able to do that. And so it would never happen. And so those assets were just, you couldn't get to them. Okay. So the judge said, I tell you what, I'm going to put you and your attorney in jail until you figure out a way to get the money out of the trust. It took them 45 minutes, So is it bulletproof? No. But that's a very rare circumstance. Typically you have asset protection, but it was just an egregious thing. This was a guy who really needed to pay the money. Everybody knew he had it, and he was being a terrible person. But
gotcha. Debbie was saying that my parents are in Virginia. So are the laws similar to Kansas? That was just
the laws in all of the states are similar, especially those states who have adopted what we call uniform laws. Kansas uses each state that adopts the uniform laws makes their own little tweaks. Kansas has adopted uniform laws and made their own little tweaks. If Virginia is a uniform law state, then their stuff will be extremely similar. I support an attorney, or have in the past, out of Idaho, and they are not a uniform law state. Now, still, most of the stuff is similar, but not as similar as it would be if they were a uniform law state. Now,
I'm going to introduce my team. Linda Morris, you can see her down there. Stephanie Kahn. We're all part of Team Kansas. And I might as well introduce Chris, because he works in the background for us. We all tell him to hand out our business cards for us, because he works at the hospital.
Gotcha.
So he sees a lot of people.
Thank you.
Really appreciate your time, Mark.
Well, yes. You're welcome.
I really do appreciate your time, Mark. I'm glad that we set this up, and we'll stay in touch and move forward. What is the best number to reach you?
The best number to reach me is 316-252-2233, which is also on my website.
Yeah.
And there's a contact page on my website, or people can contact directly with info@advancedlegalplanning.com.
Can I ask one more question?
Of course.
So you use the example of a person who's still working, who did the starter trust and the Medicaid asset protection trust.
Mhm.
Why not just have just the Medicaid asset protection trust and not have the other one?
That's a very good question, and that tells me I didn't educate you well enough. So let me try again.
Okay.
So what can we put into the Medicaid Asset Protection Trust? Can we put the bank account that we pay our bills out of?
No.
We can't.
Okay.
Because whatever we put in there can't come back to us or be used directly for our benefit. I can't pay my bills out of that Medicaid Asset Protection Trust. I can't go buy food out of that trust. So she has to have some stuff that's outside of it that she's living off of day to day. Now, what happens to that if she dies? Well, we're back into the whole probate, the three options: the do nothing plan, will plan, or trust.
And so if the house is still under a mortgage, it can still go there and you pay the bills out of your revocable living trust?
Okay, so if you have a house that's got a mortgage, and you can put it into the Medicaid Asset Protection Trust, and it won't, Garn St. Germain Act, it doesn't, as long as the trust is set up properly, it won't trigger a due on sale clause. But as far as getting the house paid for, it depends. We could do it lots of different ways. We could charge rent instead of, my trust could charge me rent. I could pay the rent in, and then the trust could pay the mortgage.
I see. Okay.
As you hit certain criteria,
Right.
then otherwise, what we're doing is we're protecting the mortgage company's ability to get at their collateral if they need to. If they lose the ability to get at their collateral, then you trigger a due on sale clause. Basically, that's what it boils down to.
Yeah.
So you need to find a way to pay it off.
Well, they can still get at it as long as with the way it's set up in the trust, they could get at it. Now, so I say asset protection, yes. Okay, so Medicaid can't get at it. If I get divorced, my divorced spouse can't get at it. But if they have a mortgage on it and it's the collateral on the mortgage, then they can get at it.
And they can hold the first lien against it.
Right.
Yeah.
That would
But where we end up with some problems is reverse mortgages. Reverse mortgages, sometimes you can put them into an asset protection trust, and sometimes you can't. And I would say it's more often you can't because there's so many stipulations.
License.
That was great. Thank you.
That was great.
You're welcome.
Yeah, I really enjoyed it.
It was fun.
Yeah.
It was fun.
Thank you guys for all being here.